should have. This is my notes from last year.
It has, Your Honor. I believe the public defender's office was quick to provide her with counsel.
Sir, no contact with any witness, defendant, victim. You're not doing yourself any favors. Taking all your anger out on yourself. The only one you're hurting is yourself. Stop doing that. Help your attorney provide a defense. That's your job.
And Your Honor, that would include third-party communication or handwritten letters that I will note for the record are scanned by the jail.
Are you going to have trouble not complying? Are you going to have trouble complying, I should say?
No.
You understand no communication through third parties, so you can't call your friend and tell them to contact Alyssa or whoever? You can't call a third party and tell them to write a letter on your behalf? You understand what that means?
Yes, I do.
No contact means you don't exist in your world. No carrier pigeon, no smoke signal, no Hallmark cards, no letters, phone calls, email, text, contact through third parties. They don't exist in your world. Have I been clear, counsel?
Yes, Your Honor. Thank you.
Any questions?
No.
That's all for the record. Thank you.
Thank you, Your Honor.
I've read your history. It's not the worst, but you have few things that are not so easy as well. What is troubling to me, before we even get to this motion, is that I do not let anyone, and I mean anyone, disrespect a public defender, disrespect a prosecutor, law enforcement, or anyone in my office. I have a stack of letters that you have written to our prosecutor, who does an outstanding job. I want to read some of it to remind you of the disrespect that you have shown. Here's a letter that starts out, "Hey, bitch Matusko, it is Yvonne Hanks writing to again. This case has been going on for over 13 months now, and still not a plea deal been offered to me." It goes on. And then you say, "I do not know what the fuck you have going on, but you need to get this petty ass case figured the fuck out right now. Right about now. What I did is wrong, but all I did was use a fake gun to take a breeze and a dab pen, a breeze, B-R-E-Z-E, and a dab pen from Amanda while I was high on multiple different drugs. This is not a hard case to solve, so why the fuck are you keeping me waiting, bitch? Prison is not the only option for this petty ass case. I understand consequences come with bad decisions I make, but bitch, I deserve to know my consequences. Bitch, let me know. So bitch, this is what you are about to do after reading this. Sit and think for 5 minutes about a reasonable plea deal for this petty ass case. Then tell Amanda about what you thought of, and then afterwards you're going to tell my lawyer about the plea deal. The end. Here's another letter. "Hey, bitch Matusko, this is Yvonne Hanks, writing your bitch ass again. Still no motherfucking resolution. Huh, bitch? It is not hard."
What was that, bitch Bishkusko? I don't even know what it is, but it's hilarious.
"For you to figure the fuck out what you want to do with me, bitch Matusko. This case is petty as fuck. This case is so fucking frivolous, okay? Yes, I know I did something wrong, but this is not some type of big case. This is not an average armed robbery. All I did was use a punk-ass BB gun to take a punk-ass dab pen and a punk-ass breeze while I was high on multiple different drugs. Bitch, stop playing and give me rehab with probation. Do not even offer me any prison time because I am not taking it. So with that being said, bitch Matusko, I need some type of plea deal with no more upfront jail time immediately. Goes on to talk about other things, about the plea deal, and then said, I did shit to people who did less than what you are doing. So fat, funky bitch, hurry the fuck up. It is time we wrap this case up. And when you bring these letters up in court, mention my reason for them. Oh yeah, I do not give a fuck about you reading these letters in court. Go ahead. I want you to. No fucks is given. Have a bad year, bitch. Oh, it doesn't stop there. Hey, what's up, bitch? What the fuck is your problem, bitch? Your bitch ass still have not come up with an offer so we can end this damn case. This case is so fucking petty. I do not know why the fuck you have not dropped my charge down to unearned robbery or larceny from the person I truly did learn my lesson. Nobody got assaulted. I was high on a few different drugs at the time of the incident. I only did that for a breeze and dab pen. I clearly have a drug problem. I have over a year of jail time served. I am open to accepting rehab and intense probation, bitch. Again, more vulgarity. And then, P.S. I don't care if you bring these letters up in court, bitch. Come with a plea. Do your job, bitch. Yes, there's another one. All right, look here, you little fat ass bitch. You continue to talk bad about me in court, including mentioning my old ass text messages that have nothing to do with this fucking case. You are worried about the wrong shit, but you still have not resolved this damn case that has been pending over a year. Not even one motherfucking plea been offered to me. What the fuck are you waiting on, bitch? Keeps on going. Yes, there's another letter. Mitch Matusko, this is Siobhan Hanks writing your whole ass again. You stupid bitch, it is time to wrap this petty ass case up. Slow ass bitch, stop taking your time. I am ready to get the fuck on with my life. Why the fuck are you keeping me waiting, hoe ass bitch? I deserve to know how much longer I am going to be locked up, pussy hoe. I do not give a fuck about you telling the judge about these letters. The fuck, you can show her shit. You can read this shit in courtroom for all I care, or shit, give me all letters I wrote you, and I will read them in court with a big smile. I don't see you smiling now, sir. And I suggest you don't, because this isn't very funny.
Oh, it's hilarious. He didn't think that would happen. And he did not apparently entertain the possibility of you reading the letters. That adds a special spice. It does. You're doing great, Judge. We're loving it.
I'm not scared of you, nor the rest of them crooked bitch-ass prosecutors that work at your office, including y'all master, John Dwayne. Oops, let me check myself. I mean, bitch Dwayne. Y'all can suck the cum out of my big black dick. Fuck every business building on Kalamazoo Street, along with the whole Michigan Avenue bitch you trying to send me to prison over a BB gun, breeze, and dab pen. The victim was not assaulted. That shit is not worth any prison time. And it goes on. You owe the prosecutor an apology. You will not write these letters. You do not have a right to assault verbally the prosecutor or your attorney or anyone in this courthouse. None of us are in handcuffs. You are. You need to check your attitude and think kindness. These words are fighting words. They're assaultive and very disrespectful. Let me remind you, these are not small charges. And I don't even have a police report. But I'm looking at these charges. Count 1, armed robbery, is a felony punishable by life or any term of years. Count 2, weapons, dangerous weapon, carrying with unlawful intent, felony, 5 years or $2,500. Count 3, weapons, felony, firearm, pneumatic gun. No, we have with that. This apparently doesn't have what that is. Is that a 2-year?
Your Honor, it's a mandatory 2-year consecutive to the underlying offense.
No, that part's missing in here. But anyways, I thought it was 2 years. It's a 2-year. Mandatory consecutive UCU. These are some pretty big charges. And it is only a small man who uses those words against a woman or against anyone. Those words do not make you strong, they make you weak. And it's very disappointing, sir. You have a mother?
Yes, I do.
You love your mother?
Yes.
How would you like it if somebody wrote those words to your mother?
I would not. I wouldn't like it.
Then what were you thinking?
I was angry. Case been at a standstill for a year and a half. I know it's not a good excuse, a good reason of why I did it, but I've just been in a dark space mentally, just ready to get on with my life. I learned a big lesson to being locked up, just ready for a resolution.
Sir, I'm here every day. Law enforcement, even on vacation, will call me. The jail will call me 24/7. I'm not unknown. Your attorney in his office is not unknown, and neither is prosecutor's office. If you had a problem, you tell the sheriff. The sheriff's going to call us, one of us, all of us, and we're going to help you. These letters hurt your case. If you think that I'm going to entertain a bond after I read those angry words, those fighting words, the answer is no. So y'all can make your record. But when I look at this, I look at danger. I look at threats. A lot of anger. We're going to get this resolved. I don't know what's going on here. I think we've had a few pre-trials, haven't we?
We have a final pretrial and a trial date set. We have our final pretrial set for mid-March, Your Honor.
It's March 11th, Your Honor. We have a pretrial with a trial date in April.
So shall we have the final pretrial? And in regard to these letters, I'm thinking maybe we have contempt. These are threatening.
You think? I think you definitely have contempt if you want it. I don't know if it's necessary because he just admitted to serious crimes via his letters. So he's going to get rung up that way. But if you want contempt, yeah, it's there for you, Judge.
Contempt carries with it 93 days and or $7,500.
Well, Your Honor, we are still attempting to negotiate a plea offer here. I would simply respectfully request that we keep that window open until that March 11th date. It's my understanding that the Madam Prosecutor would like to meet with the complaining witness again and then extend a final offer. I'm going to be gone from the 27th through March 4th, Your Honor, but I will make every effort to make sure that Mr. Hanks is well informed of what his offer ultimately is. And then we will be ready to proceed on March 11th. And then if we have to proceed to trial at that point, then so be it, Your Honor. We have been negotiating in good faith on both sides. Certainly, Mr. Hanks' alleged statements here have added another layer of complexity here to the negotiations, to put it mildly, understated. But respectfully, Your Honor, we are making every effort. I'm making every effort on my end. So is Chief Deputy Matusko, to try to see if we can find some common ground here to a resolution before a potential trial date, which we have set. And I will be prepared and able to proceed with the trial.
Nice work, counsel. Honestly, proceeding with dignity under horrible circumstances. I applaud him.
On that date, if needed, Your Honor.
Ms. Matusco, are you asking for contempt?
Your Honor, this time I would be asking the bond be revoked. We are set at $250. I believe the court rule allows it. The court did not read into the record the final statement on the final letter that I did receive in January, and that was.
What it said?
I don't know if yours are in the same order, but it says, P.S. I did a lot of bad shit to people who did less than what you are doing to me right now. Bitch, you better be safe. That ain't no threat either. That's a direct threat to
That is a direct
the prosecutor here. It's not that we're using angry words. It is that we are literally threatening. And this has been Mr. Hanks' consistent MO whenever he doesn't get his way. So rather than asking the court for contempt, it is my intention when I make my record as to the conditions for pre-trial release to ask this court to simply revoke bond. So there's no way he gets out prior to that.
And I remind us that it was just
Oh, this guy will cry too. He will.
so appalled reading all of it, but it is also in capital letters what you just read. Yes, I did a lot of bad shit to people who did less than what you're doing to me right now. Bitch, you better be safe. That's all capital letters. Capital letters means anger and is threatening. Under it, it says that ain't no threat either, meaning it's going to be a real issue. It's how I read. Like you're going to make good on it. Not a threat. Bond is revoked. Any more letters? Bad behavior? Every single letter? Every single bad behavior will be in 93 days. Contempt. Consider this a huge warning. Sir, you can't treat people like that. I don't know what anger issues you got. We're going to get you some treatment, mental health treatment in jail. Because if you continue this path, you're going to be in prison. You're not doing yourself any favors. You're not keeping our community safe. Your anger's getting the best of you. You've been in front of me before. You've always been respectful. So I don't know what's wrong. I am sure that it's very difficult being young and in jail. But you see, we have a retail fraud. Height was revoked. You have defrauding an innkeeper. You have CSD fourth degree by force or coercion. We have, do we have a pending charge? We have
He's earned it.
2 files.
Your Honor, the pending charge was when he was out on tether. He cut his tether and was found in possession of cocaine. So the pending charge is having cocaine in his pocket.
So you got drugs, and you've already acknowledged in here that you were high and not making the best decisions. So you got to address these issues, and we're going to have that happen in jail right now. Is there a final offer, or are you still working on that?
Your Honor, it's my intention to meet with the victim in this matter. We've been working around work schedules, my own personal schedule, within the next week, so that I will convey that final offer to the public defender's office. I understand Mr. Sykes will be out, so if you'd like me to put additional individual.
I'd be like, if I was a prosecutor, my offer would be, I'll tell you what my offer is. He pleads open to the court, and I recommend the maximum sentence. That's my offer.
On that email, once I can convey it, I can absolutely do that.
I will be monitoring my emails while I'm on vacation. I have to prepare for a trial anyway, so I will make sure that we get this information to Mr. Hanks. Thank you.
All right, and did you give me the date of the final pretrial?
I think it's March 11th. I didn't write down the time.
Well, this has to be a final. I have a final pretrial was last September, so I don't know what happened, but I know there's been a lot of changes and other things that have happened. So
So I can address that.
okay,
Previously, this case was being handled by Dale Callwriter from my office, who was the assigned prosecutor in this case. Mr. Hanks made the decision to write him letters as well. So when I was covering this court, I took this case over to remove Mr. Callwriter from the file to hopefully stop those letters from happening. Those are not attached to this motion, as I wanted to update the court as to what has transpired since the last time this court denied bonds. And it's clear that the letters were getting more threatening once they were directed towards me. So I took this case over in September. Mr. Sartz and I began negotiating, exchanging information, mitigating information, discovery, to see if we could get a resolution in this case. So that's why that final pre-trial was adjourned back in September.
All right, March 11th, final pre-trial. You're here.
Yes, Your Honor.
And then when is the trial?
It's April 24th.
I am scheduled to start a trial on March 10th, but I believe that's going to be motion day on Wednesday. It's in front of Judge Stokes. So is the 11th a Tuesday or? I'll make sure we get this handled, Your Honor.
March 11th is Wednesday.
March 11th is Wednesday, so I should be here.
I'd like you both to look up backup dates, whether it's earlier or later than this April 24th date. We need to get this to trial, because I know that in April that week, I think we have probably 4 or 5 scheduled that we did. And I think a couple of them are older than this. So we need a couple backup dates, unless you want to prioritize this because he's in luck.
I will work with Mr. Buxton to see where we are on the list and then communicate that to Mr. Sartz as well. If a backup date is necessary, Mr. Sartz and I can work the schedule to get one.
You're remanded to the jail. You're going to work with community mental health, see medical, psychological, go to CATS, get some treatment over there, sir. This cannot continue. I know you don't like jail, but you got to change what you're doing out in society, or you're going to be in jail and then you're going to be in prison. And this does not make me happy to do this to you, but I don't know what else to do. We have public safety. And I'm fearful if I were to let you out again, it would get worse. So go into jail and work on what you need to work on. And there'll be no more times like this. Otherwise, it's 93 days, every single letter. And that does not count against any other sentence. That is separate crime. Have I made myself clear?
Yes.
Do you have any questions about what I mean?
No, I understand.
Is there anything that you need over in the jail that you're not getting?
No, can't think of anything.
Quickest way to get out of jail is to behave. Start working on your rehabilitation. Talk to your attorney. Don't be rude, crude, angry. We didn't commit the crime. You're innocent until proven guilty beyond a reasonable doubt, but for bond conditions, I have to look at public safety. What I see here is not safe. You're entitled to your trial and you're going to get one. But I also want you to consider these letters that you admitted bad behavior, criminal behavior. So I don't know if that's going to play in. But you didn't do yourself any favors, sir. You said who you were, you wrote these, and you talked about what you did. Those statements can all come in at trial. There's a pretrial notion about motions that this isn't going to come in. Set it in front of me, but I don't know how you get around this from coming in if people want to bring it in. You can talk about that with your clients. You need to talk about that with your attorney. Have I made myself clear, sir?
Yes, you have.
Very good. Is there anything else we need to address?
Yeah, Sharon, I believe we addressed it at the December court hearing. The no contact order with the victim in this case is Amanda Jean Smith. We also added Alyssa Hill. Alyssa Hill is either a witness or sometimes a co-defendant. I know Mr. Sartz and I have worked to get her an attorney appointed because some of the letters implicate her as well. I just want the court to reaffirm that no contact order and make it clear to Mr. Hanks that that includes reaching out by way of a third party. He recently made phone calls to a third party to make contact to Alyssa Hill. That third party did cut him off, would not engage in much of a conversation, but I just want to make it clear that any contact, whether directly or indirectly with Ms. Hill, would violate this work order.
Do you understand the no contact order? And Ms. Hill was already added. I have a note here, Alyssa Hill, potential witness, and she may have some culpability. We need conflict counsel for her. And she may have some culpability, and we need conflict counsel for her. So I don't know if that's occurred. It should have. This is my notes from last year.
It has, Your Honor. I believe the public defender's office was quick to provide her with counsel.
Sir, no contact with any witness, defendant, victim. You're not doing yourself any favors. Taking all your anger out on yourself. The only one you're hurting is yourself. Stop doing that. Help your attorney provide a defense. That's your job.
And Your Honor, that would include third-party communication or handwritten letters that I will note for the record are scanned by the jail.
Are you gonna have trouble not complying? Are you gonna have trouble complying, I should say?
No,
You understand no communication through third parties, so you can't call your friend and tell them to contact Alyssa or whoever? You can't call a third party and tell them to write a letter on your behalf? You understand what that means?
yes, I do.
No contact means you don't exist in your world. No carrier pigeon, no smoke signal. No Hallmark cards. No letters, phone calls, email, text. Contact through third parties. They don't exist in your world. Have I been clear, counsel?
Yes, Your Honor. Thank you.
Any questions?
No.
That's all for the record. Thank you.
Thank you, Your Honor.